Hello everyone, and welcome back to another episode of the Darrell Brooks saga. I'm sorry for the delay, I was on a work trip. I only have one more next week and that's it for the year, so hopefully no more interruptions after that. But today we're going to continue with day 10, and that's going to be fun. Day 10 is continuing with how when he escaped, because he didn't, after the parade. So I just want to say thank you guys so much for subscribing. We are 15, as of the recording, we're 15 subscribers away from 1,000, which is gonna be awesome. Thank you so much. Share this video, give it a like, and let's continue growing together. All right, let's get into the video.
Good morning, Judge Sue Offer, Leslie Basie, and Zach Woodchow appear on behalf of the state of Wisconsin.
Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charges instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to being called that name.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is in street clothes, wearing a suit and tie and mask.
I don't consent to being called that name, Your Honor.
All right, we got all the classes.
For the record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case. And other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that,
he just called him out on it. He's like, we know your name. You said your name. At this point, we are so far down that we know your name that it's not even funny anymore. But we are on a new day, day 10. So that means we got new suit watch for everyone. I know you guys love it. We have the classic black suit that's oversized. We have the classic gray shirt and the purple tie. And I think this is the third time that he wears this suit. So, you know, everyone starts at a 10. So we're going to subtract 2 points because it's Darrell Brooks. So he gets, that's an 8. And we're going to subtract another point because he's oversized. So that's a 7. We have to take another point down because it's the third time that he uses this. So that's 6. My math is wrong. I don't know. I'm gonna give it a 5. I'm gonna fail him on this suit because he's wear him too many times.
I
don't agree to that, Your Honor, or consent to that.
Your lack of consent is noted. As I told the parties on Monday, I had excused one of the jurors for a health reason, and it has come to my attention that I now have a second juror with the same health concern. Out of an abundance of caution, I am going to bring the jurors out to question them about their, whether any of them have any concern about continuing to serve on this jury, given the health concern. I am referring to a COVID concern.
No emotion.
Your Honor, will we be addressing subject matter jurisdiction?
All right. He just heard that one of the jurors had a health concern. And the first thing that comes to mind is, oh, I'm going to go back to subject matter jurisdiction. Good, Darrell Brooks. Never change.
No, not at this time.
No.
Still has yet to be proven for the record. I don't know if the audio's on.
It's on. I wish it was off.
I wanted to make a record in open court and to ask each one of you if any of you have any concerns about continuing your service in this case due to exposure to COVID. And so I'm just going to go through, first of all, juror number 11. Do you have any concerns about continuing your service in this case, specifically related to COVID?
No concerns.
All right, thank you. Let me actually go back to, would the fact that you may have been exposed in any way interfere with your ability to pay attention and ultimately render a verdict in this case?
No.
All right, juror number 48, if you could also answer those two questions.
No concerns, both ways.
All right, and thank you. Juror number 46.
No concerns.
Thank you. Juror number 34. No to both. Thank you. Juror number 27.
No, also to both.
Juror number 30.
No concerns to both.
Thank you. Juror number 1.
No concerns to both.
Thank you. And what's your number? 6. Juror number 6.
No concerns to both.
Thank you. And juror number 14. I'll just start there.
No concerns to both.
Thank you. Juror number 10.
No concerns to both.
Juror number 51.
No concerns to both.
Thank you. Juror number 45.
No concerns to both.
Thank you. Juror number 19.
No concerns to both.
Thank you. Juror number 41.
No concerns to both.
Thank you. And juror number 3.
No concerns to both.
Thank you. I'm going to excuse the jurors then, and then when we're ready, we'll have you brought back out. And thank you so much.
All right, they're troopers. They've powered through it. They don't mind if they get it. I got it once. I was asymptomatic. I just got it because at work they made us test for it, and I that's how I knew that I got it. I wouldn't know otherwise. But I know people that had it, and they had a really bad time. So good for them.
So, unless there are anything related to that, I have a couple of other issues I need to address this morning.
What?
Go ahead.
The person that's, or the two people rather, that are having the COVID concerns. I know you said you wasn't going to ask them had they test positive or the results of any testing. Do you know if there has been exposure on their end to COVID exactly, or is that just a caution thing?
My understanding is that I've had 2 jurors test positive throughout the course of this trial.
Right.
And
I'd make a further record that they're the only ones within 6 feet of each other. Obviously, you're not within 6 feet of any of them, but that's a good question to ask, and I'm glad you asked that, and I wanted to make a record of that as well.
yeah, that would be my question to it. I guess in reference to me myself just having the same concern a few weeks ago. So that would be the reason why I would want to know exactly any details that could be provided.
I'm providing all the details that I will. Again, for the record, you have not been exposed, from my opinion, because of the distance that you are away from them, and my understanding based upon my review of county policy.
The entirety of the jury, though, have they been exposed in any way?
Why do
I
you
don't
care?
know the specifics because of the 6 foot rule, and no one has asked me to investigate that further.
Yeah.
Wouldn't it be smart, though, to see?
No. They just say that they don't have any problem with it.
I don't believe that's necessary under the circumstances.
Yeah.
Well, if anything, just for future reference, like, what if it plays a part later on?
Well, I'll certainly take your concerns under advisement, and if I believe any further questioning needs to be done, I'll do that. At this point, I don't believe it needs to be done, but I'll think about that, and I'll take it under advisement, and if I change my mind, I'll let you know.
Yeah, I'm just saying, because if anything, it probably would be smart for the long run to make sure no one else was compromised, considering that.
Let me make
Yeah.
a record there. No one has indicated they are compromised. I don't think we can make assumptions about how anyone who's been exposed or tested is feeling. You can be asymptomatic and test positive. You can have mild symptoms. I trust my jurors that they would report if they're not able to sit through the proceedings.
Seemed like the circumstances were different when it was me.
Yeah, because you were faking it.
Just saying.
I mean, he's just the only thing that this is an issue is because he wants to stall. He wants to delay, and he wants to maybe get rid of some jurors and bring some new back, so he can try to convince them of this sovereign stuff. So that's what I mean. He doesn't care about their health. He just cares about delaying, and he doesn't like when it was something about him because he was faking it and no one believed him.
Are you making any specific requests given this information?
Well, I believe that the jury clearly all congregate together. I think it would be smart to make sure everybody is tested.
No.
I mean, that's it would be smart to do that.
I'm not going to mandate testing for the jurors. That much I can tell you.
Good.
So that request is denied.
And the grounds for the denial?
I'm
Doesn't
not
need
going to mandate that the jurors be subjected to testing. They're the ones who indicated they are comfortable being here. They don't have concerns. And again, I would trust them to report to me if anything changes.
I'm quite sure, though, that all the jurors Monday said they didn't have any concerns as well. And then now today, someone else, same thing being said. I just feel like it's smart for them to be tested, so it doesn't come up again in the future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go. It's just smart to, like you say, err on the side of caution.
I appreciate that. I'm going to continue. I understand what you're saying, but given the responses of the jurors today, I'm going to continue. I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that, though, Mr. Brooks, I have been thinking about your request yesterday. And I know I indicated to you that I would require you to be there. I've rethought that. I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this. I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
I was still confused about why did there even need to be a jury view.
Because it's a
my whole
murder
thing.
weapon.
I don't see the relevancy of it.
It's the murder weapon. You use that to ram into people. They need to see it. What?
And I also didn't agree with or consent to having to be part of something that I don't see as relevant.
You don't have to be
I
there.
appreciate you making a
I just
record
told you
of
that.
that. Do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Fine, don't go. Whatever.
My question to you, though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person. I'm a human being. And no, I do not consent to or agree to being present at a jury view.
Fine.
All right, then I'm going to honor his request.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
He's saying that because he doesn't want to be there, it can't happen? No, you're saying that you don't want to be there. It's gonna happen anyway. It's like he has a right to be there, and this is like he having like a ticket to go to, I don't know, a Simon and Garfunkel concert, and he's like, no, I don't want to go. And then, right, we're gonna go. We gotta go watch them. And like, how are they gonna play if I'm not going? You just don't want. You're just forfeiting for. You just don't want to go. That's fine. We're gonna go anyway. We're gonna go have fun.
I'm asking the question though. How can it take place without my consent or agreement?
If you don't, it's going to take place. That's how I'm going to answer that, sir.
Yeah.
So you not going there is not going to prevent it from happening.
My Lord,
But you can forfeit your right or to
I
be
didn't-
there
I
by your
didn't-
conduct. And
I
by your
didn't-
conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've
Yeah.
had some time to think about that further. I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that
Well,
would be for me to give you an explanation of the law.
no,
I'm
it
just
would
going to
be-
tell you that I'm not going to require a written waiver from you in order to honor your request to not be at the, or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
Sir, I'm not
The
going to
way-
go through all the law that applies to that.
The way
This is
I-
my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But
No.
your lack
Yes.
of consent is not going to stop the jury view. It's
It-
going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it
It's a
in.
car.
okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view.
So?
And that was the whole issue. And yesterday I was told about the, I don't know how you say it, the colloquy or
Colloquy.
however you say it. I don't know how to pronounce it.
I know
which
what
was-
I said, and
Yeah.
I'm telling you I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which
Why do we care the way that you interpret the law? It doesn't matter what you think. The law, you didn't write the law, so shut up.
the law is designed for to be interpreted by the people. The way
You are not the people. You're a person. You don't need to interpret anything.
I interpret that is I have the right or essentially to be there or not to be there.
Yeah.
There still has to be an agreement or consent. That's how I interpret the law.
My ruling
No, you have the right to be there or not to be there, but you don't have the right to stop the jury view.
on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your objection is well noted for the record. I need to keep going though on the pattern and
I'm
jury.
informed that you need to keep going. I'm not trying to stop you from continuing to go.
But I'm gonna.
I'm merely stating for the record that there are things I do not understand how they're being permitted
No?
versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing. I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not
That
arguing.
we will continue on
I'm
with the
seeking
next
to
topic.
understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going
Doesn't
to
matter.
explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties
May I
2
respectfully
documents.
reject that ruling and take exception to that ruling?
Your objection is noted. I'm
For the
moving
record,
on
may
to
I
jury.
request a legal and factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me.
He's going down the
okay?
checklist.
I give you an opportunity to raise your objections and to make your legal arguments,
raising
and then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not
And
disruptive.
it's interrupting and it's disruptive.
It is definitely not disruptive.
Well, if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone. And once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152.
Well,
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because you
You're
didn't,
interrupting.
you said I have the right to object, and you didn't let me even get to the
Remember when he said that he wasn't trying to stop you from going?
objection.
I did, sir.
No, you
okay?
didn't. I was right
Your
in the middle of
objection
it.
comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before
please
we
stop.
even finished,
That's not true. Okay?
you
It's
said
not
I'm going to
true.
make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
going
the
to
time to
spend
think.
hours on end making a ruling about a jury view on something I've already decided. All right? So please, I'm asking
Well-
you to stop. Stop
No, this-
interrupting me.
You can't,
And please
just
listen.
disregard the United States Constitution, which has a
I
supremacy
absolutely
clause.
am not disregarding the
You
United
are.
States
You're
Constitution
not
or the
honoring your oath
Constitution
of
of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay,
Here we go
Mr.
with
Brooks,
this.
you're starting to cross the line. You've already crossed it, but I want to keep going. I
didn't
want you in
cross
this
any line.
courtroom.
Take him out.
But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this
So again,
morning.
you're holding me in contempt.
All right. Jury instruction 152, as the state had an opportunity to review
Is
it.
that a judicial determination that I'm being held in contempt?
Instead of referring it as being in the
All right,
Waukesha
we're gonna
County.
take this opportunity I'm sorry to interrupt Susan. We're gonna take this opportunity to do suit watch on Zach and the officer. I forgot his name. I'm sorry. So Zach has a light gray suit, a white shirt, and a blue tie. I like it. It's fresh. It's something like you will wear on the summer, and I like it. So, and it's regular. I'll still give him a 10 plus the 2 extra points for being Zach. So he gets a 12. Kudos to Zach. The office, the private investigator over here, he's like a darker blue with a red tie and the white shirt. I'll give it a 10. It's fine. It's a good suit. I don't have any problems with it. Tell me in the comments what you think of the suits. It's fun to know what you guys think as well.
County Jail, I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Seem to being called that name. What do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote unquote jury view.
Yes.
I accept for value in return for value this document.
Okay. Read it.
Now, I'd like the record to reflect, I still haven't received my original copies of my filings here this morning.
They don't need to give it to you.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
That's not the
Mr.
question.
Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully,
sorry?
for the record, may I do that?
Wow, why would you snap at her? She's just asking you a question. You're saying stuff about something else. How can she know that you were reviewing the document? This is the kind of person that he is. And I hate it. Hate this guy.
You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same. It's the same document.
They literally just said the changes, my guy.
That was
Reference to
accepted for value,
the-
returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. I believe the rest is the same.
So it was a couple words changed.
Yeah.
That's my understanding.
So it's the same document.
It is not.
Let me know when you're finished reviewing it, and
I
I'll have a
don't
question.
have to review the same document that was reviewed yesterday. Accepted for value and returned for value yesterday.
Right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself.
With that, sir, do you have any?
I don't
Position.
fundamentally understand that. I think everyone's well aware that I'm in custody. So how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody. How does changing the wording change what's already known?
I hate his argument. His argument is that it doesn't matter. So, if it doesn't matter, then let's change it. Your argument is weak, my guy.
Thank you. This instruction will be read while we are still in the courtroom prior to the parties in the court going to the Sallyport for that viewing, and I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding
After all that fighting, now he wants to go?
is we'll have sort of assigned places, and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
I have a question to that.
Okay.
how come none of that knowledge of how it would be conducted was discussed with me?
They're discussing it
I
right
didn't,
now.
I didn't know anything about
What?
how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we have
So
preliminary.
I don't understand it.
We had preliminary discussions at the time of the request back in August, when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now. I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it. Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file, and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same
So-
details that's being discussed right now at this moment?
All right, Mr.
Yes.
Brooks, do you have a request as it relates to any of that?
Is there any point to this?
Well, yeah, I'm still trying to understand the whole how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely.
No.
With bailiffs, I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly,
And-
Your Honor?
So, obviously, when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are
The security has to be left at the discretion of the sheriff's department.
Actually,
That
these
we
are
have-
leg shock devices, not shackles.
They're not.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged
But you don't look like a convict. So you don't look like a prisoner. That affects mentally to them.
to see
That is to your benefit.
shackles?
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that
Yeah.
you're making about your lack of understanding, I need to move on with the other topics
There is
I
a
need to
specific
cover.
request. Why do I have to have ankle shocks on my
No one
ankles
said anything about it.
to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
She never said that, you gaslighting monster. She said like shackles. What?
No, these are not shackles. They're a shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention. But we are going to move on this morning.
So I should discuss that with the sheriff.
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No,
I'm
it's
not
one
going
document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, again, I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th.
I don't get why he wants to have all that, and I also don't know why he wants to, I don't know, why he thinks that because he says something that it needs to happen. And this is the first time that I notice his nails. Why are they so long? They don't get him like nail clippers at jail? They're so long. I don't get why.
Time.
As
Every
a
filing
courtesy,
that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
No.
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this
Can
one.
I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I
you may-
have the copies. I don't have the originals.
Why
All
do
right,
you
I'm
want
going to
the
move on.
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to
I don't
something?
believe there's any other preliminary issues we need to address.
I'm still wondering when I'll get the copies back for the ICFs that I filed.
That's not
I
with
can't
her.
answer that. I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her and make communication form and ask her for those. But I'm not going to address that any further on the record.
Good.
All right,
They
let's
should
bring the
be.
jury up.
It's kind of funny that they disappeared.
They didn't disappear.
No,
They
I
didn't
see
ask
them
for
disappear
copies.
Fact, not
before.
in evidence, sir. So
They haven't disappeared before. I've always got copies. What's the difference now? So I have to readdress her the same thing
Yeah.
in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
Yeah.
My understanding is they were forwarded to me, sir. But
So what happened to this one being forwarded to you?
sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like
coming
you're trying
in.
to
We're
avoid
going to
it. That's
we're
what
going
it
to
seems
continue
like.
with the trial. So thank
Just like
you.
you've avoided subject matter jurisdiction. You haven't proven that on the record.
She addressed that. You tore the paper up.
Are you aware as to whether or not the school district maintains security cameras at the buildings on the school district property?
Yes, we do.
Overruled.
All right.
Foundation.
One more before we go. He goes with the suit with Suit Watch today. We got this gentleman. I don't know his name yet. but he has the blue suit, the light blue shirt, and the orange tie. I like it. I don't like the pattern of the tie, but I like the color. I like the orange with the blue. So I'm gonna give it a 9 for that. The whole ensemble, I'll give him a 9.
Witness may answer.
I'm sorry.
Yes, we do.
Okay. And specifically, is there school district property located at the address of 222 Maple Street or Avenue in the city of Waukesha?
Yes.
What?
Overruled, it's foundational.
Is there more than one security camera on that building?
Overruled, the witness may answer.
Yes.
How many are there, sir?
Overruled.
When the police came to you in the days following November 21 of 21, did they ask you to check a certain day and time on the video recording for the building at 222 Maple?
Objection. Second.
Overruled, the witness may answer.
Is what asked
Had you
him.
changed or altered the content of the recording in any way?
Objection. Leading.
Overruled, the witness may answer.
No, I have not.
Do you recognize what we're seeing there, sir?
Yes.
Could you please tell us what is shown on the front screen of Exhibit 157?
Objection. Leading.
Overruled, the witness may answer.
This is the side of our Lindholm Administration Building at 222 Maple.
Okay. Do you believe the video contained in Exhibit 157 will be a true and accurate depiction of the events from this location on November 21 of 21?
Objection. Speculative.
Do you want him to see the video first? Why don't you show him the video first?
Well, the video is 20 minutes long, Your Honor.
Oh, all right.
Or I'm sorry, 11 minutes long. Do you recognize what is shown in Exhibit 158?
Yes.
Please describe it.
Objection. Leading.
Overruled, the witness may answer.
This is our rear parking lot at the Lindholm Administration Building.
At that same address?
222 Maple, yes, that's
Okay.
correct.
Is this a second camera?
Objection. Leading.
Correct.
Overruled.
Entire video is 11 minutes in duration. Based on the testimony of the witness, I do not intend to play any of it at this time, but I would move to admit 158.
Objection. It's not intended to play. What's the relevancy?
It's evidence.
The objection is noted. It's overruled.
Also, I didn't catch it, but did you notice that he has the Bible on top of the microphone? I think he just put it there so the jury can see it.
Do you recall when you saw those videos?
I saw those Monday morning when my detectives came and asked me to review video footage.
And do you recall the name of the detective that you reviewed the footage with?
I do not recall the name of the detective, no.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
Were you subpoenaed at any time?
Yes, I was.
And do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled, the witness may answer.
The district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Do you recall if you were contacted by the plaintiff in this matter?
Here we go.
Grounds.
So, this witness only provided video surveillance for the state. So he has nothing to ask him about. So he just goes straight to the plaintiff's thing. So I don't know why.
Sustain this to the form of the question.
Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement.
Grounds.
Sustain this to the form of the question.
Cut him off. He's gonna continue asking about the plaintiff, and we're gonna object. He's gonna The same
Do you
song
recall
dance.
having a phone conversation with the plaintiff in these
Same objection.
grounds?
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I'm not sure who the plaintiff is. Can you define that for me?
The plaintiff would be who's bringing the claim.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified this is irrelevant questioning.
We'll see what his question is first.
I asked it.
Please ask your question again so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
Cut him off. Just stop with the plaintiff stuff. We hate it. We all hate it, and we know it's pointless.
Do you even know if there's a plaintiff in this matter?
Objection
Grounds.
argumentative.
Sustained as to the form of the question.
Have you yourself filed any complaint in this matter?
Objection
Grounds.
irrelevant.
Overruled, the witness may answer, sorry.
I have not, no.
Do you know of anyone who filed a claim in this matter?
Objection
Grounds.
irrelevant.
Overruled, the witness may answer.
I do not.
Do you have any security
All right,
cam?
we're gonna leave it here. We're gonna continue tomorrow with more witnesses about the recordings of their houses. All right. Thank you for watching. I'll see you guys tomorrow. Sorry for the long pause between the videos. I just have to work. I'm sorry. But give it a like if you made it this far. I'll see you guys tomorrow. Have a great day. Bye-bye.